All right, good morning, counsel. Back on the record in the Simpson matter. Defendant's again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden. Matter is here for motions to quash certain subpoenas, and the court has also issued its ruling regarding the renewed pitches motion, which should be pretty much self-explanatory. And Mr. Douglas, Ms. Clark, as soon as the custodian of records comes, because I'm ordering the disclosure of certain items, however redacted, for certain content, which will take some time. All right. I anticipate, however, that we'll be with Detective Lange and Mrs. Goldman perhaps for the morning session. All right. All right, let's proceed then to the motions to quash subpoenas. All right, good morning, counsel. Your appearances for the record.
Good morning, Your Honor. Stephen Warren Solomon, Saltzman, and Jameson for Michelle Abdaran.
Good morning, Your Honor. Melvyn Douglas Sachs for Kathy Randa.
All right, counsel, who wishes to go first?
I'll begin, Your Honor.
All right. Good morning, counsel.
May it please the Court. We as citizens do not give up our rights because Mr. O.J. Simpson or anyone else is accused of a crime in this case. My client, Michelle Abdaran, is not a defendant in this case, is not accused of any crime, is not involved in any wrongdoing. She's only listed as a witness for the defense in this matter. My client was a housekeeper for Mr. Simpson's family in 1988 through 1990, from 1992 back through up into and including the early part of 1994. Thereafter, she left the Simpson employment, went to work in a residence in Beverly Hills as a housekeeper. The District Attorney's Office, in its present form of this subpoena, if left untouched, would allow anyone at any time to get anyone's records. Let me look at the approach that the DA has taken in this case. First of all, Your Honor, on November 10th, they issued a subpoena. The subpoena was from November 1st, 1994 through February 10th, 1995. As the court can see from those dates, the commencing part of the subpoena was 4.5 months after the homicide. The subpoena was returnable on the 24th in this courtroom. As required by civil law, since the motion to quash is civil, counsel and my firm filed a motion to quash on the 23rd. We filed a declaration of my client and supporting points and authorities. This court issued a minute order sealing those records, and those phone records have not been turned over to the police department or the DA. They're presently under seal before this court. The declaration in question, Your Honor, as seen by the first board, indicates that the materiality is, quote, filed by the DA, necessary to prove the charges filed against the defendant. That statement, Your Honor, does not comply with CCP 1985 or 1985.7. There is no factual showing of materiality. What I'd like to do with the court, there are 3 key cases. We filed extensive points and authorities. I can only comment that the District Attorney's Office has not filed any points and authorities in opposition to the law on the subject. The first case I'd like to go into, Your Honor, is People versus Schmidt. In the Schmidt case, the defendant was on trial for conspiracy, grand theft, and other matters. The district attorney in that case filed a motion to suppress subpoenas issued by the defense. The court, in affirming the trial court's quashing, indicated, and it's shown here on the first board, Your Honor, quote, the allegations of defendant's affidavits were wholly insufficient to show what material facts, if any, would or could have been proved by the documents sought to be produced. And then the court, on the next page, sustained the quashing of it. The key case, Your Honor, is Johnson versus Superior Court. In Johnson versus Superior Court, the language was, quote, necessary to prove the allegations in the case. And our language is, quote, necessary to prove the allegations of the defendant. The Johnson court said, no good, sustain the quashing. Now, subsequently, in the Pacific Automobile case, Your Honor, the Court of Appeals said that subsequent facts adduced in court are not sufficient basis to be used to support the subpoena duces taken. Now, what has happened in this case, Your Honor, yesterday morning around 9 o'clock, I received by fax from Ms. Lewis a supplemental declaration alleging some, quote, new facts that they're now trying to use to bootstrap the subpoena that was issued some weeks ago. Under the Pacific Automobile case, that authority does not allow for that, Your Honor. Now, I note, Your Honor, that has the court received the supplemental declaration?
No, I have not.
Your Honor, I filed that yesterday morning. I'm sorry that it was not given to you.
Not in my notebook of items.
Your Honor, I believe the court would benefit by reading that before.
Let me check with Mrs. Robertson. Mrs. Robertson, do we have the supplemental declaration in support of the SVT? Proceed, counsel.
Your Honor, my concern about the supplemental declaration says in a footnote, we're filing this response under seal to protect the phone numbers in question from being revealed to the public by the press. I want to go into the facts of the supplemental declaration, but I won't refer to the phone numbers. Is that appropriate, Your Honor?
Certainly.
The declaration is approximately 5 pages, and it concerns not only my client, but about 80% of it concerns Mr. Sachs's client. I'll only refer to those paragraphs that relate to my client, Your Honor. The district attorney now, and it's signed by Cheri Lewis yesterday, so this is what they're trying to use to bootstrap the subpoena issued some weeks ago. It says on February 10th, the district attorney's office issued a subpoena DT. And then they say on paragraph number 5, on January 31st, 1995, district attorney's office interviewed a woman by the name of Ziona Friedman. Ms. Friedman is a maid who currently lives in West Hollywood, and I'm leaving out the addresses and phone numbers. It says over the 8-year period prior to the murders in this case, Ms. Friedman was regularly called by the defense maid, Michelle Oberon, to help her at the defendant's Rockingham estate. And then they talk about some work that maid does. On February 8th, 1995, Ziona Friedman was interviewed a second time at the district attorney's office. During that interview, she supplied many additional details of information she says Michelle Oberon, which is my client, Your Honor, told her regarding the 1989 spousal abuse incident between the defendant and Nicole Brown Simpson. And then the only thing left in there regarding to my client is paragraph 8C. Ms. Friedman said she talked with Michelle Oberon by telephone almost every day. One of the things Michelle told her was that Michelle had a lawyer, Tuet Shapiro. Michelle had not called Friedman in a week, the week prior to February 8th. Ms. Friedman was very worried and scared about that since she was accustomed to Michelle calling her every day. Then the only other thing in the declaration related to my client is, quote, the telephone records of my client are necessary to aid in assessing the credibility of Ms. Friedman by aiding in determining the extent of her contact with those witnesses. What we really have here is a lot to do about nothing in regard to Ms. Friedman. If they want to see who Ms. Freeman talked to, they can look at Ms. Freeman's telephone records, and they do have a subpoena out for that. The subsequent declaration, Your Honor, doesn't have any legal effect in terms of the subpoena that was issued some month ago, and that's the Pacific case. It's also interesting, Your Honor, that the staff of the district attorney's office has not responded to any legal authorities set forth by myself or Mr. Sachs. And what you have to balance here, Your Honor, is my client has a right to privacy of association. Who she calls on her own phone, her friends, and what she does is her own business. She is not a defendant in this case. She is not accused in this case. She's not involved. I would suspect, however, that the DA will probably come in again and try factually something else. The only relevance I can see to any part of this, Your Honor, is Ms. Zia Freeman's phone record. And I would suspect and suggest on behalf of my client that if the court wanted to take those records in camera, look through my client's phone records, and deduct out anything except if Ms. Zia Freeman's phone records appeared there, then the district attorney could have what it wants. Then the court would protect my client's right to freedom of association, and that would be the least obtrusive way to resolve this problem, Your Honor. And unless the court has any suggestions, I would submit that that would be the best approach to protect my client's right and give the government what they want, but not open this up to allowing anybody at any time to look at any phone records. Because based on what they have done here, I suspect the defense could take every prosecution witness and request all their phone records, and the prosecution could take every defense and request their phone records. And that's not what it's supposed to be, Your Honor. I'll submit it, Your Honor. Thank you.
Mr. Sachs?
Morning, Your Honor. Good morning. Yeah. In regards to the situation here, we're really concerned with the citizen's right to privacy. And in dealing with the issue as to why my client objects, as any citizen has a right in California to object to anybody looking at her residential telephone records, is because this legislature in the state of California, when they enacted 2891 of the Public Utilities Code, they made a finding that it was of paramount importance that the residential telephone records of all our citizens in this state are accorded the right to privacy. And only if the government can show by the use of lawful process in a criminal case can they obtain those records. Now, in this situation, Mr. Solomon has alluded to the deficiencies in the declaration in support of the subpoena. And when we look at the language where it says necessary to prove the charges filed against the defendant, the cases we've cited show that there's no factual basis of materiality or good cause that would justify the issuance of the subpoena. And if we use that language and say that justifies the issuance of a subpoena, and that alone would overcome the absolute right to privacy that the legislature has enacted under the Public Utility Code, except when a good showing in a criminal case is made, the court would authorize the seizing of 300 defense witnesses' residential telephone records. And if we took the same affidavit and changed one word and said necessary to disprove the charges filed against the named defendant, the court would be authorizing the seizure of 400 of the prosecution witnesses' residential telephone numbers, which would include Detectives Lange's residential telephone numbers, Mark Furman's, Philip Van Adder's, and Ron Phillips. And I don't think the court would allow the defense on no greater a showing that is shown in this affidavit to seize not only 400 records of prosecution witnesses, but the detectives as well and other police officers involved in the case. Now, in dealing with the right to privacy, what we're talking about in this courtroom are citizen rights. This court so far has been concerned with certain rights of the parties. They've been concerned with the rights of the prosecution to get a fair trial, properly so. The court's concerned with the rights of Mr. Simpson to get due process of law and a fair trial, and properly so. The court's been concerned with the rights of the jurors and the rights of those jurors to have their anonymity and to not be harassed by the press and the public. Nobody has addressed, and properly so. Nobody's addressed to this point the rights of these witnesses. And what we have in this case is 700 people that are on a list. They're all American citizens. Under the statutes enacted in the state of California, all of these witnesses have a right to privacy, unless there's a showing of good cause to go beyond what the legislature said is a paramount, a right of paramount concern when they pass the legislation. So I'd submit to the court, number one, that we have to look to the fact that witnesses have not been spoken for up until this point under these subpoenas. Now, my client has had 8 subpoenas served on her in regards to this litigation. 3 subpoenas to testify before the grand jury under the guise of the Al Cowlings investigation, but all of the questions that she was asked before the grand jury concerned this case itself. Since she went to the grand jury, she's received 3 other subpoenas to testify in this case, one of which she was on call for over 3 months before she was released. She's also received, in addition to those 3 witness subpoenas, one other subpoena ducis tecum that required her presence, and these 2 subpoena ducis tecums for telephone records. The one being litigated today, and there was another one that was previously issued in July, but she had no counsel at that point, no opposition was raised. Now, in dealing with the rights of the witnesses and the fact that nobody has spoken as in terms of witnesses' rights, we have a lot of situations arising where there have been comments made in this courtroom. And I know the court is trying to be very fair to all concerned, but there's certain things that play out in this courtroom that get televised throughout the country, and it looks a little different to the witnesses that it may look to Your Honor. And I will say one thing about Your Honor, you've been very accommodating as far as I could see to all the parties that have appeared before you, to all the people that have come into this courtroom have been accorded nothing but the most utmost respect by this court. And I think you've established a friendly environment for the people coming before Your Honor. But some of the things that have happened through the litigants plays out through the public, and the witnesses that are under subpoena see this. And there's been certain comments made, first back in September, there were comments made about my client and some evidentiary issues in regards to some evidence that may have been destroyed. And under a proffered offer of proof that nobody required, my client sort of had a little character assassination made public. Now, tied in with that, there were other comments made about defense witnesses that the prosecution said, I'll tell you about the defense witnesses. They're felons, they're heroin addicts, they're court-certified pathological liars, and felons. Now, nobody mentioned what witnesses, defense witnesses were being spoken about. But what happens is beyond this courtroom, when the witnesses see it, it has to have a chilling effect on people. Because as far as I can see, anytime a defense witness hears their name mentioned at this point, they should be doing two things: jumping for cover and seeking legal representation. Now, in dealing with that, that gives an overall picture of the chilling effect that can happen when comments are made in the shape of litigation, where in a normal case, nobody would know about it. Your Honor would hear a comment made, the parties here would know about it, a few courtroom hawks that would be sitting in the courtroom would know about it, but it wouldn't go any further. But here, when we have these types of situations concerning witnesses, and why I'm concerned with witness rights, is because it does have a detrimental effect on the people that are coming in as citizens to do their civic duty, to take the witness stand and to testify to the best of their ability. And as the public has seen, as the court well knows, some witnesses testify better than others due to one reason or another. So tied in with the history of why I'm concerned with witnesses' rights, and more specifically with the subpoena, my client has every right to have her privacy protected, not only under the First Amendment, but under the statutes we cited in our points and authorities. And unless the government can make a good showing as to why that privacy should be invaded, the privacy should be protected. Now, in dealing with the supplemental declaration, I still don't believe that it makes a factual statement that would satisfy a showing of materiality and good cause. But if the court were going to take a quantum leap and say that you feel it does make a showing that would justify some of the records possibly being turned over, I would concur with what Mr. Solomon suggested in the way of accommodation, that the court in camera look at the records and limit any release of those records, for the sake of argument at this point, to the prosecution, only limited to the two parties that they're talking about, Ms. Friedman and Ron Schiff, and limit it to those two numbers alone, and preserve the right to privacy as far as the other calls are made, because as we showed under the First Amendment, the right to privacy of Ms. Randa, as well as any other citizen, covers their personal contacts with the people they associate with day in and day out. And what more of a personal contact do you make other than face-to-face than when you call somebody from your own residence? Secondly, I'd like to address the issue of the violation of the consumer protection law under 1985.3, where there is a burden placed on the prosecution or any other party seeking to get a subpoena from a consumer record, which the telephone company records are, that due notice has to be given to the consumer. In this case, it's my client, Kathy Randa. The prosecution under 1985.3 subdivision E is required to serve a copy of the subpoena with the declaration on the consumer and give them notice that they have a right to contest the subpoena in court. Now, I would like to state that in regards to the first subpoena issued last July, no notice was given to Ms. Randa, and I filed a supplemental declaration to that effect. She received no notice on the first subpoena. She received no notice on the second subpoena. In addition, the prosecution has known since September the 19th that I have been representing Kathy Randa, and they made no attempt to give me notice by supplying my office with a copy of the subpoena or the declaration. And this was even after I requested from Ms. Clark and Ms. Hodgman by way of fax on both the 18th of February and the 21st of February that my office be provided a copy of the subpoena and the declaration so we could take appropriate action. The only reason I received a copy is I requested the assistance of Mr. Cochran's office, and through their good offices, I did receive a copy. Now, the only reason I knew to ask for a copy of the subpoena wasn't because we received any notice from the prosecution. The only notice we received was from Pacific Bell. And Pacific Bell has a company policy, not required by law, but a policy of their company to notify their consumers and their customers when a subpoena has been served upon the company for those records. If it wasn't for the fact that the telephone company sent my client a letter, this motion would have been heard in silence and secrecy because the court would have had no opposition. The subpoenaed records would have arrived in court, and pursuant to the subpoena, it would have been handed over to the prosecution. So with a total element of secrecy and no notice being given to my client, her privacy would have been invaded in violation of not only the Public Utility Commission law as set forth in Section 2891, but in violation as well of the Code of Civil Procedure Consumer Notice Requirements of 1985.3. Based on two intentional violations of the law, I would request this court issue sanctions at this point, because this is no different than the situation where sanctions have been issued against the defense and the prosecution for failure on both sides to comply with 1054 of the Penal Code. And I think that it sets a standard that the prosecution, if they're going to issue subpoenas, or if the other side's going to issue subpoenas as well, they've got to comply with the law to protect the rights of these witnesses, because these witnesses are American citizens. They're entitled to every protection under the Constitution and every protection under the special statutes that the state of California has passed to deal with this issue. And based on those arguments, I would submit that the subpoena should be quashed, and the alternative sanctions that the court deems appropriate should be issued against the prosecution for the violation of my client's rights to notice under the law and an attempt to invade her privacy without due notice.
All right,
Thank you, Your
Mr. Sachs, let me ask you this. With regards to your request for sanctions, what do you think are appropriate?
Well, my client's, to be quite frank, my client hasn't incurred any legal expenses because, without breaching the confidentiality of the attorney-client privilege. I can just say that my work here is pro bono. But I think some monetary sanctions may be appropriate just as an out-of-pocket expense to the district attorney, but I'm not looking to unjustly enrich myself. But I think in terms of sanctions, the court isn't concerned with dealing with monetary sanctions. I think an admonition to the district attorney's office with further compliance with the requirements under the statutes that I've cited would be appropriate. And I think if any of this evidence comes before the jury, that an appropriate sanction should be assessed against the district attorney, where the jury is informed of the fact that the prosecution in regards to my client's rights, when she's called as a witness, has been infringed upon. And when they cross-examine about telephone records and so forth and so on, I think an appropriate admonition to the jury, informing them that the district attorney acted improperly in trying to seize the witness's records. And I think it's something that I would ask the court to heavily consider, and I don't think it should be taken lightly. And it sets the standard, as this case commences down the line, that either party issuing subpoena duces tecums that would fall within the purview of this statute or some other right to privacy being invaded is complied with. Because I think all the witnesses should feel as comfortable as possible coming into this courtroom to testify. I said it once before in another forum that the only people that like coming into this courtroom are the people that work here. Your Honor, the attorneys, the court staff, we do this for a living. We're used to what goes on here day in and day out. But the average citizen that's called upon to come through these doors and take that witness stand does have a lot of apprehension because they can see what happened to Rosa Lopez, whether it's good, bad, or indifferent. It was 4 days on the witness stand. Detective Lange's been on the witness stand for a long period of time, but there's a little compensation in his regard. He's more or less a professional witness because with his job, over the years, he does testify on a normal basis. But the average citizen here in America that's called into this courtroom to testify, especially the fact that it's going into every big city, small hamlet, township, and county throughout this great land of ours, knows that whatever they say, not only is everybody seeing what's being said, the public at large, but their friends, associates, the people they work with, and all of the commentators on TV are nitpicking and analyzing to the 10th degree exactly what that witness said, how he said it, or she said it, whether or not she's credible or maybe lying, mistaken, or whatever. And that does have a detrimental effect on these people. So what I'm concerned with, and I think, even though I've pointed out, I think the court has been over-accommodating to be as generous and courteous and as courteous to everybody that works in this courtroom and comes in here. There is a chilling effect that these witnesses feel just from the fact that it's It's abnormal to come in and have to testify, and most people think they're going to get on that witness stand, they're going to be grilled right and left, and they don't know what to expect. But what's happened in this case, when it goes out to the public at large and people see what happens to each witness as they come in, most people, if they had their druthers, would never want to come in and testify. At this case, other cases, you know, you work your nerve up, you go in, you testify, and then you're back to what you normally do. But in this case, with that camera in this courtroom, it has an extreme effect on the witnesses, and I think that when I ask for sanctions, it's not just in terms of my client alone. I'm concerned with the witnesses who have to come forward, whether they're prosecution or defense witnesses. They have certain rights, and I think the court should bend over backwards to protect their rights as well. And I do have to apologize. When I was talking about protecting rights, the victims' rights are properly protected in this case. We have two decedents. The court has every intention to treat those people with dignity and the respect that they're entitled to. I'm just asking for the same thing for my client and the other civilian witnesses that are called upon to do their civic duty and come in here and testify.
All right. Thank you, Mr. Sachs.
You're welcome, Your Honor.
Ms. Lewis? Morning.
Good morning, Your Honor. Thank you. First of all, Your Honor, I think we need to back down a little bit from some of the rhetoric and see what the scope of this particular hearing is. While it's, I think, evident that I agree with protecting the rights of witnesses, particularly given the motions that I've filed and argued regarding Detective Mark Furman and his privacy rights, we are here today to talk about two particular subpoenas that were issued for phone records of two particular persons. Michelle Abduran, who was the defendant's maid for many years over in Rockingham, and Kathy Randa, who was the defendant's administrative assistant for probably 20 years, something like 20 years. Now, what concerns me, Your Honor, is that the court has not yet read the supplemental declaration that I filed. As Your Honor knows, the District Attorney's Office issues thousands of SDTs per month throughout the county for records of all sorts, including phone records. We are aware that it is the custom and practice of Pacific Bell to alert consumers should they have any concern about that. You know, I don't want to go into a lengthy rhetoric myself about the cost currently of the criminal justice system, the difficulties our office has in obtaining appropriate budgeting, especially given the current three strikes laws. We do the best we can under the circumstances, Your Honor. Now, because there was concern raised in this case with the privacy of the two particular witnesses involved, I took a look at the declaration which we sent out, which is a pro forma declaration, frankly, that says that they're necessary to prove the charge as the records are. That's something that our office routinely puts on subpoenas, as I'm sure Your Honor is aware. And to take the time in every case and every type of subpoena for records to have to detail the reasons for it would require substantial additional time on the part of DAs handling all these cases for which we issue these thousands of subpoenas. But, Your Honor, because the privacy concerns were raised, I did I set forth in detail the reasons why we indeed subpoenaed these particular records. And the timing is self-evident. We are not trying to manufacture facts later. These records were subpoenaed on February 9th and 10th, and they followed our second interview of Ziona Friedman, which was on February 8th. That lady is also a maid, and she was a maid who Michelle, the defendant's maid for approximately 8 years, called regularly to assist her when the defendant was entertaining. She's also someone, Michelle and Ziona Friedman were close together, and in fact, their records were subpoenaed on the same STT. And Ziona Friedman has not sought legal counsel to move to quash the subpoena for her records. When we interviewed her on February 8th, and this is set forth in more detail in my declaration, she initially, in being driven to the interview, she expressed concerns to one of our DA investigators that she felt she was being pressured and harassed by Ms. Randa to disassociate herself from the prosecution. And she was very adamant about those concerns. When we got to the interview, the taped interview, she denied that, but she still acted very scared, said she was very scared, very concerned. It appeared that she'd wanted to talk to us, but she was terrified of doing so. In addition, she set forth additional information that she had not provided with regard to Michelle's recounting of the 1989 domestic violence incident. If the court recalls, I believe the court heard testimony during trial and or during the representations made during the 1101B hearings, that Michelle was the person indeed who tried to pull Nicole Simpson out of the car, out of the police car, back in 1989. So, and Michelle as well is someone who had, during the period in time in question, called this other maid, Ziona Friedman, who has been cooperative with the prosecution, almost every day, according to Ziona. So that her telephone records would be the one that would show those calls to Ziona, rather than vice versa. In addition, the court will recall the testimony of Ron Shipp, where he indicated that he was considered himself a good friend of the defendant and of Kathy Randa, and he alluded to himself and Kathy Randa as sharing, mutually supporting each other with regard to drinking problems. It was the allusion there. And because Mr. Shipp did not come forth to the prosecution until January 28th, I believe it was, with revealing the defendant's incriminating statements about having had dreams of killing Nicole Simpson. Because he did not come forth until that date, the phone records of Kathy Randa showing calls during the time in question from November, December, and January, not only to these maids in question, but also to Mr. Shipp, further corroborates his explanation that he was a friend of the defendant's, and his bias, his natural bias, was for the defense. And it does corroborate why he did not come forth until late in time in revealing that incriminating statement of the defendant's, which he finally testified, I believe, was because he did not want Nicole's blood on his hands, and his guilty conscience could not stop him any longer. I would certainly ask the court to read the declaration in detail. What we have is a situation here, Your Honor, where let me make mention of one other thing. Ms. Randa was notified with regard to her phone records, which were obtained earlier, by Pacific Bell. It's attached as Exhibit C to Mr. Sachs' supplemental declaration in support of motion to quash Kathy Randa. I'm sorry, in support of motion by Kathy Randa to quash subpoena ducis tecum. And that shows that she was notified. In addition, Your Honor, Mr. Sachs may be unaware, but we did provide the discovery to the defense in this case, who has standing for that those phone records were also obtained pursuant to a search warrant, which covered not only those records, but several others having to do with that period of time of the week during which the defendant was finally arrested on the 17th of June. So she did, but she was notified because we also SDT'd them. She was notified by Pacific Bell about those. We are here at a point in time, Your Honor, where these witnesses have had notice now. Have started to say hired, but I guess not hired. They do have attorneys. They have attorneys who have filed points and authorities on their behalf. The court, I believe, has the records before it. The court, we're in a situation where the court is able to make a judicial determination based on the additional facts I set forth in our supplemental declaration. And that is all that should be required at this point in time. We certainly don't want to unduly harass either of these witnesses by resubpoenaing the documents just so I can set forth my 4 or 5 page declaration within the context of our standard SDT format. I also wanted to mention a couple of cases that, it's actually one case by the California Supreme Court, Associated Brewers Distributing Company versus Superior Court, a 1967 case at 65 Cal 2nd, 583 at 587, and a case which quotes that case and invokes its holding, People versus Bigelow, Bigelow, a 1988 case at 200 Calap 3rd, 59 at page 61. Both of those cases talk about when the subpoena power is invoked to secure discovery, the good cause and materiality requirements of Code of Civil Procedure, Section 1985, which relates to the issuance of subpoenas, must be governed by discovery standards. And they also say, quote, the objective is not merely the discovery of admissible evidence, but also effective preparation for trial. So when the court reviews the supplemental declaration which I filed, I would ask the court I would remind the court that even though we're in the middle of trial and the court is deciding the admissibility of evidence, the standard on discovery is whether the records sought will tend to lead to admissible evidence or would enhance the effective or allow for the effective preparation for trial. So, Your Honor, while Mr. Sachs talks about the rights of 300 witnesses or so forth, we had good reason to subpoena these particular records in question, and I set forth those reasons, which were not after discovered facts, but facts that happened right before the time we subpoenaed them, and that's why we subpoenaed them. I did all that to allow the court to make an intelligent decision as to whether there indeed is materiality shown. And in addition, I don't think I mentioned in the declaration, but of course these records are not available from any other source, and that's always one of the reasons given why records are necessary from a particular source. So I would want that in the record as well. Of course, these phone records are not available from any other source that we're aware of.
Ms. Lewis, do you have any comments regarding the request for sanctions and whether or not the policy of Pacific Bell to notify their customers is really sufficient compliance with the Public Utility Code?
I believe it is sufficient compliance, Your Honor. I would not want Your Honor to set precedent that would require, I don't know how much money, but substantial additional money expended by the budget allotted to the district attorney's office from the Board of Supervisors, which comes from the taxpayers. Because if we were required to notify the consumer in every case, that would substantially increase the expense to the district attorney's office of having to do so, and especially given our knowledge that it is Pacific Bell's custom and practice to submit, whenever they return a subpoena, their points and authorities and their notification, with the records.
What's the policy of the General Telephone?
Well, my understanding is the policy of all the phone companies is the same, but I have to tell you I haven't called GTE in particular and asked them that.
All right. Mr. Solomon, any response?
A couple.
I'm sorry. Let me ask Ms. Lewis one more question. Ms. Lewis, both Mr. Solomon and Mr. Sachs have suggested that, assuming the worst-case scenario, that I find that there is some materiality and that rather than require you to reissue a subpoena with a 5-page declaration in support, that they're recommending that the court review the phone records in camera and redact those records just to reflect the phone calls between the persons that you've indicated are material, rather than allowing the prosecution unfettered access to the complete phone records of Ms. Randa and Ms. Abdurrahman.
I think that would be appropriate, Your Honor. With regard to Ms. Randa, I think, as the court will see from the declaration, there are other persons which would be relevant. For example, Ziona Friedman was advised by Kathy Randa, I believe, I've set it forth in detail in my declaration, to call Bill Pavlik. She said, something to the effect of, "My God, please, for OJ, call Bill Pavlik before you talk to the prosecution." We didn't find this out until the second interview we did of her on February 8th. And she said she did call Bill Pavlik, indeed. And she claims that Mr. Pavlik told her only to tell the truth. Well, I think the length of a phone conversation between those two would be useful in assessing the accuracy of that statement. And she also indicated that she called A.C. Cowlings.
All right, Ms. Lewis, forgive me for interrupting you, but my specific question, though, is that would you accept that, a redacted phone record rather than the complete phone record that you've subpoenaed?
Yes, Your Honor. And we would just need to make the court specifically aware of the phone numbers that we were interested in.
All right, thank you. Mr. Solomon.
Yes, Your Honor. I've never heard of the largest, public law firm in America saying that they don't have the time, effort, ability, or staff to fill out a subpoena due to taken appropriately. If in the civil court I had done what the district attorney had used and come in and said, well, we don't have the staff to do it, they'd be looking for me to do another job, Your Honor. You can't delegate the functions of subpoena DTs to one line. You've got to use the appropriate language to protect people. Now, I'm not worried about the rest of the world. I'm worried about my client. That's all I represent here. Now, I've heard no justification other than this is the way we've done it for years. Well, the consumer notice requirement, they don't even give. 1985.3 is mandatory, not on the telephone company, but on the government who was ever attempting to issue the subpoena. I've heard no justification for the court not to impose sanctions. And the question you asked, Mr. Sachs, is what kind of sanctions to impose. Well, first of all, it should be payable to the court, not to cancel. And second of all, it should be appropriate with any other type of sanctions that this court has given in the past, either against the prosecution or the defense, and whether or not you admonish the jury is something that's not really an issue, I think. I think it should be a financial sanction to impose upon both the prosecution and anybody else who appears in this court that if they're going to subpoena records of people, you better comply with the law. I would also comment that the comments made by Ms. Lewis regarding who said what to where, etc., is all hearsay declaration by Ms. Lewis. There is no declaration in this court, in this case, for these subpoenas by any of the investigators or by Ms. Clark, who was in the interview. It's by Ms. Lewis, who heard it from X, Y, and Z. So we have a trail of hearsay here. And also, in regard to my client, they're not asking for records when she was there, Your Honor. They're asking for records from November 1st through February 10th, some 4.5 months after the incidents. In spite of all that, we'll still go along with a redacted version to save us from coming back here again. But I think, as Mr. Sachs indicated, it is appropriate in this case to sanction the prosecution. Thank you, Your Honor.
Thank you, counsel. Mr. Sachs, any brief response?
Yes, Your Honor. In response to the declaration itself and what we've heard is hearsay on hearsay, we're not here to litigate the truthfulness of that declaration. It's just whether or not that declaration would suffice as good cause. My client categorically denies any allegations of wrongdoing made against her in that declaration. But in dealing with the position of the district attorney's office, my law office doesn't have a $125 or $150 million a year budget. And yet I find time to draft a declaration in support of a subpoena ducis tecum as an attorney practicing by himself. I can't understand why attorneys claim that they don't have the money when all it does is take time and effort to properly draft a document. I think the court, if they want to brief on something, you expect an issue to be fully briefed by both sides and not to get sloppy lawyering in the process. Now, in addition to the sanctions situation, I think Ms. Lewis missed the point. She's telling this court that sanctions shouldn't be imposed because of the policy, the company policy of Pacific Bell. My client did get notice. Well, my client got notice that there was a subpoena, but she never got the subpoena. And it's not the requirement under the law for the Pacific Telephone Company to give notice to their subscribers. They do that as a courtesy, but if they stop that courtesy tomorrow, who even gets any notice that they're holding a subpoena for those records? 1985.3E of the Code of Civil Procedure requires on the government or any other party seeking a subpoena under these circumstances to give direct notice, God bless you, give direct notice to the consumer or their attorney. The district attorney didn't stand before this court and say, in the future, we're going to give notice to the witnesses. She said, we're going to rely on Pacific Bell to continue with the company policy. And that's not what the law requires, and I think that emphasizes the reason why the court should seriously consider the requested sanctions being imposed at this time, because they're not going to change their ways, they're not going to change their minds. They're just going to continue to do things in the same way that they think is appropriate, which amounts to nothing more than governmental abuse against a citizen of this state that's protected under the law to receive the notice that the law says they should get. And to do otherwise is a violation of the law. And to stand before this court and say we're going to continue to do the same old thing because we don't have a 32-cent stamp to send out the subpoena to Ms. Randa or her attorney is the basis of which they're stating they're going to continue to not comply with the law. And I find that ludicrous that the price of a 32-cent stamp and the cost of Xeroxing 2 pieces of paper, which is the subpoena and the declaration to support, is the basis to intentionally continue to violate this law. And I'd submit it on that basis.
All right. Thank you, counsel. I'm going to take the matter under submission so I can read the declaration filed by Ms. Lewis, and I will issue a written ruling. All right. Thank you, counsel.
Yeah, just for the record, I read the transcript of the interview with Zayona Friedman, and I listened to the other taped interviews, so it's not hearsay upon hearsay upon hearsay.
Thank you, counsel. Record should also reflect that it's GTE that responded, not Pacific Bell. All right, I'm going to need to take a brief recess. We have the custodian of records here from the LAPD, that I need to chat with on the record in chambers. So we'll take about a 15-minute recess. Our jury panel. Ladies and gentlemen, good morning. My apologies to you for the delay this morning. We've been in session since 9 o'clock. I had two matters that I had to deal with regarding the production of evidence by third parties, so I had to rule on those motions before we could start today. All right, let the record reflect that Detective Tom Lange is still on the witness stand. Good morning again, Detective Lange.
Good morning, Anna.
He is on redirect examination by the people. Ms. Clark, you may continue.
Good morning. Detective Lange, you were speaking yesterday of your reasons as to why, in your opinion, based on what you saw in the course of your investigation, you did not believe these to be drug-related murders. You recall that?
Yes.
In that regard, sir, do you recall indicating to Mr. Cochran that there were superficial inquiries made concerning the topic of whether or not drugs were involved in these murders? Do you recall that?
Yes.
Can you please explain to us what you mean by superficial inquiry?
Checking the location for drug debris or drug paraphernalia, for weapons perhaps, for anything that would indicate narcotics activity on the part of the victim or the suspects.
And so was that an examination that you made at the crime scene?
Yes.
And was the condominium, was Ms. Brown's condominium examined by police?
Yes.
Were there any drugs found?
No.
Were there any paraphernalia for drugs found?
No.
Any scales or anything like that?
No.
Any paraphernalia for the usage of cocaine
No.
or marijuana?
No.
Did you find any writings in the way of pay and owe sheets concerning monies to be paid for a kilo of this or a gram of that?
I did not.
Was any material like that ever found in the apartment, the condominium that was shown to you later?
No.
Was Mr. Goldman's apartment examined also?
Yes.
And was anything related to drugs or drug paraphernalia found in his apartment?
Not to my knowledge.
And would it have been brought to your knowledge, sir, as the lead investigator?
Calls for a conclusion.
Was the evidence was the apartment, the findings made in the apartment of Ron Goldman made known to you, sir?
Yes.
And was anything made known to you concerning the search of his apartment?
Complete the question.
Let me start another one if you're on. Were any drugs or drug paraphernalia seized from Mr. Goldman's apartment, sir? This is the basis of his opinion.
All right. Ladies and gentlemen, this information is limited only to the state of mind of this detective. It's not necessarily true. It's his state of mind.
Thank you.
Ms. Clark.
Not to my knowledge.
Other detectives searched Mr. Goldman's apartment, is that correct?
Yes.
Was that at your direction, sir?
Yes.
Did they turn over to you any evidence of drugs or drug paraphernalia found in Mr. Goldman's apartment?
No.
Was there any pay and owe sheets indicating monies paid or received for the sale of drugs?
No.
Were there any scales or cutting agents or debris associated with drug usage or drug sales found in Mr. Goldman's apartment?
No.
And is that, did you complete your answer with respect to what you meant by the superficial inquiry? Is that what you meant?
Sustain.
Did you have anything further to add? I don't know if I cut you off, sir.
No, that's it.
Now, with respect to, you also alluded to yesterday the manner of killing as another reason why you felt these were not drug-related murders. Do you recall that, sir?
Yes.
You referred to the fact that
Overruled foundation.
You
for the
referred
next
to the
question,
fact
I
that,
assume.
in your experience, it's usually firearms, guns that are used in drug-related murders?
It's been my experience, yes.
Was there anything about the nature of the wounds that you observed, either at the crime scene and in the course of the autopsy, that caused you to conclude that these were not drug-related murders?
Yes.
And what was that?
This appeared to me to be an overkill or a rage killing.
And how is that different than what you see in drug-related murders?
Overruled. Overruled.
Again, in my mind, it appeared to be motivated by rage and not narcotics related.
In narcotics-related cases, what kind of wounding do you typically see as compared to this case?
Overruled.
Generally, you would see a gunshot wound is what I've saw normally.
I'm sorry?
Normally a gunshot wound. The murders that I've handled are normally by gunshot wounds as opposed to excessive slashing and stabbing of the victim.
All right, I believe that on cross-examination also you discussed with Mr. Cochran the possible order of death, whether Nicole was killed first, whether Ron Goldman was killed first. Do you recall that?
Partially, I don't recall testifying to an order of death.
And what is your opinion in that regard, sir?
As to who was attacked or died first,
Yes.
from the evidence, I really can't tell.
Could be either one.
Could be either one.
Yeah, just tell my desk, leave the court to reopen direct for the purpose of showing the jury a videotape.
All right. Proceed. Let me just instruct the jury what that means. Ladies and gentlemen, reopening direct means that the prosecution is going to go into something that they did not present previously in their first examination of Mr. Lange, Detective Lange, and I've allowed them to do that rather than to recall the witness at a later time, since he's here. Ms. Clark?
Thank you, Your Honor.
It's plain. Do you want that plain?
No, not yet. Not yet.
All right.
Thank you. Sir, I'm showing you a photograph that's been previously marked as People's 57. Do you recognize the location shown there?
Yes, it appears to be the walkway at 875 Bundy, the crime scene.
Can you tell by what you see in that photograph who that officer is?
No.
I'm going to put that up on the Elmo. Or let me also show you Defense 1011. Can you tell us, does that appear to be a copy of the same photograph but with the logo American Journal blocked out?
Yes.
All right, Ms. Clark, you have on the Elmo which of the exhibits?
This is People's 57, Your Honor.
All right.
All right, sir. Now, can you tell us at what time the crime scene in this case at 875 South Bundy was broken down?
I believe it was approximately 3 or 3:30 that afternoon of the 13th.
Okay. You don't presently recall exactly?
Exactly? No.
Would it refresh your memory if you looked at the chronologue?
Yes.
Go ahead.
Last entry shows 3:45 p.m.
Now, after the crime scene tape is taken down, what is the significance of that? What does that mean?
That the crime scene, in effect, has been broken down, and that the investigators and the officers involved are leaving at that time.
Okay. And does that then permit people to walk inside where the crime scene, the area where the crime scene tape had been previously blocking off?
Well, there'd be nothing to prevent that.
Is there anything improper at that time for police officers then to walk inside the area that had previously been blocked off by the crime scene tape?
No.
Can you tell by looking at this photograph, sir, whether the crime scene tape has been removed or not?
No.
Did you see an officer stroll up the walkway in the manner shown in this photograph during the time the crime scene tape was still up at
No.
875 South Bundy?
No.
The following videotape, I'd ask you mark Peoples next in order, Peoples 101.
101.
Can you tell us what's happening here in this portion of the tape, sir?
Yes, the officer is removing the crime scene tape, and the scene is apparently being broken down.
And you said that was approximately 3:45?
Yes.
Then at this point, the crime scene tape has been removed.
Yes.
Does that mean that the investigation has basically been completed in this area?
It's leading.
So, what does that mean with respect to whether or not the crime scene investigation, or the status of the crime scene investigation in this area?
Oh,
At this particular time, it's been concluded.
And stop. I'm going to show you again People's 57 and Defense 1011 and ask you if these appear to be a still frame taken from the video we're now looking at that's been marked People's 101.
Does appear to be a still of that video, yes.
May I ask permission of the court to let the jury, to pass these pictures to the jury while this is still on the screen?
yes.